the role of bioenergy in the Clean Power Plan, a major policy addressing carbon pollution state by state in the U.S. Despite the recent Supreme Court stay, many states continue developing their individual state implementation plans, and the need for information and clarity regarding this policy remains. So our webinar series continues to explore the role of renewables, especially bioenergy, in the state-level plans being designed right now. The goal of this webinar series is to take stock of what we know, what opportunities this policy opens nationally and locally, what information from recent literature should enter this topic of conversation, how we can conduct fair and balanced advocacy on behalf of the industry in which we study and work, and what uncertainties stakeholders in the bioeconomy face when engaging on this topic. All webinar sessions in this series are recorded and have been released on YouTube to allow later viewing and sharing via the series webpage, again linked in the chat pod on the left. As I said, today's presentation is the 7th in this series. The series began with an overview of the context for American carbon policy and biomass in the Clean Power Plan, with subsequent presentations focused on civic framework. In March, we looked at the intersection of the CPP with traditional forest product markets and the need to carefully evaluate modeling results in planning, power industry, and most recently we heard from Forest Management Agency representatives in Oregon and Washington who are working proactively to build wood energy into their state CPP approaches using a vision that prioritized forest health. Again, all of those presentations are available as recordings on the series webpage for free viewing, along with a longer series schedule that used to detail future presentation but now serves as an archive for past presentations. And that webpage URL can be found linked in the chat pod on the left or in the notes for the recording. Today's presentation concludes this series and will also be recorded and archived similarly. We hope that these 7 presentations will act as a long-lasting reference for stakeholders working around Clean Power Plan issues, filling in some of the knowledge gaps where they exist. There's more than enough uncertainty around the policy itself, and we'll hear a lot about that today, so we must do what we can to reduce uncertainty about the actual tools available to the states, with bioenergy being one, and the major issues associated with them. Though this series is ending, the facilitators, organizers, and many of the speakers remain available to engage with you on these topics. We hope that you'll reach out to them and to their parent organizations, including the New Bio Project and Penn State Extension. After today, the New Bio webinar series will resume its wider programming content focused on major research gains, commercial progress, demonstrations, and case studies, and other new work on biofuels, bioenergy, and bioproducts in the Northeast. We hope you'll join us for those. The presentation today, entitled The Legal Landscape for the U.S. Clean Power Plan, will be presented by Lara Fowler, a mediator and attorney who focuses on environmental and natural resource law, including all things water and energy. Prior to joining Penn State in 2012, she worked on public policy issues for the Oregon Water Resources Department, attended the University of Washington School of Law, and practiced with a law firm in Seattle. As a private practitioner, she mediated issues such as groundwater storage rights, chronic flooding issues, and reallocation of water supplies in major population centers. In addition, she counseled private clients on various regulatory matters related to both water and energy. She now holds a joint appointment as a senior lecturer at Penn State Law and is the assistant director for outreach and engagement with Penn State's Institutes of Energy and the Environment. She's currently researching how water, energy, and conflict play out in a region that includes Marcellus shale development, the Chesapeake Bay, biofuels, and flood-prone rivers. Lara also teaches an energy law and policy course at Penn State Law, and she recently co-authored a chapter on law and policy related to biofuels. So I strongly encourage you to seek out that book and dive deeper into her work after today's presentation. Lara, we're so pleased to have you close out this series for us, and we're very much looking forward to your presentation.
Great. Thanks for the overview of the series as a whole. If there are any volume issues, please let me know, but otherwise, hopefully the audio is good here for myself. What I wanted to do, and what I was talking with Sarah about doing, was kind of putting an end to this overall series of kind of giving you the legal landscape for where the U.S. Clean Power Plan currently stands. And I will give you the spoiler alert, I guess, is that this has been a long, strange trip. the realm of lots of things that have never happened before. And I'll walk you through why that is the case. I'm not going to dive so much into the details of the Clean Power Plan so much as the sort of swirl around everything. This slide shows a link, as Sarah has given, the series of seminars. It did start with kind of an overview of it and then dove into different pieces of it. So I'm just trying to put kind of an end to it. The other spoiler I will give you is that this month, actually September, is a very interesting month for the Clean Power Plan, so the next month coming up. The DC District Court of Appeals is actually scheduled to hear a major argument on the Clean Power Plan on September 27th, and I'll come back to that in a minute here. Quick review of the Clean Power Plan, just make sure we're all on the same page. President Obama issued an executive order in August 2015 to set the first ever national standards to address carbon pollution from power plants. This is him making the announcement, and this was a linchpin and a key piece of the commitments the United States made as part of the Paris discussions on climate change. And so the real goal was, how do we actually make sure that we reduce carbon from our biggest source, coal-fired power plants or other fossil fuel plants, with the goal of reducing the emissions green 2030. It was handed to the Environmental Protection Agency to basically manage the process. But as I'll get into it, although the August 3rd, 2015, so just about a year ago, last week, was a major marquee moment. A lot of things predated that major announcement and also postdated it. The legal background here, in 2007, very importantly, the U.S. Supreme Court decided for the first time in Michigan versus the United States Environmental Protection Agency, EPA, required EPA to regulate greenhouse gas emissions as a pollutant under the Clean Air Act. A number of people actually, and a number of nonprofits, in particular non-governmental organizations, pushed Environmental Protection Agency at that point to regulate, saying that greenhouse gas emissions and carbon dioxide were actually a pollutant. At the time, EPA said, no, they're not, we can't do this. And they pushed this case all the way through, where the High Court said, in fact, you can and you must regulate this as a pollutant. This is a groundbreaking decision here in 2007. In 2009, EPA issued what they call gas emissions affect the public health and welfare, thus allowing them to regulate, in this particular instance, motor vehicles and various stationary sources. Keep that in mind because EPA just actually issued another endangerment finding over the last couple of weeks related to aviation that I will come back to again at the end of the presentation. In 2014, the U.S. Supreme Court decided a different case, really recognizing that EPA has the authority to regulate large stationary sources. This case also overturned a number of different EPA's regulatory authority in other areas for new types of sources that they had not previously regulated. But what you have is really looking at the regulation of greenhouse gas emissions. In 2014, the EPA actually issued draft Clean Power Plan rules. So this predates, again, by a year, the decision or the announcement by the President. This received a ton of comments, more than 2 million comments from a whole variety of different entities. At that time, actually, industry in 12 different states filed a legal challenge. Again, this is 2014, before the President ever made any announcement. The court came back and denied it as premature, basically saying in no uncertain terms, this is actually the DC Circuit Court, we have never made a decision on a preliminary rule. It's not timely, it's not ripe, go away. But clearly, folks were already starting to line up their legal arguments, again, even predating when the rule became final and when the President made his announcement. In 2015, EPA issues the final rules, a set of rules in the Federal Register in July. President Obama makes his executive order announcement on August 3rd. There's a difference between rules and the plan. Again, an executive order under the plan was announced on August 3rd, and it wasn't until it was issued and published in the Federal Register on October 23rd did that count as a date that looked like a 22nd. And again, in that time period, November, December, President Obama committed to greenhouse gas reductions at Paris as part of the Council on Parties 21 21st assembly of those parties. It's referred to as COP21. But the Clean Power Plan as a linchpin in the commitments that he was making on behalf of the United States. Different states had different mandates under the Clean Power Plan depending on the regional power grid and each state's power source. Again, just reviewing this, the Clean Power Plan basically recognized, hey, we have 3 different sets of interconnections, the Western Interconnect, the Eastern Interconnect, and then Texas, the ERCOT, Electricity Reliability Council of Texas Interconnection. Not at all connected to this, of course, is Alaska and Hawaii, which were exempt from this. But they basically divvied up and said each state has to reduce emissions by a certain percentage by 2030 to get to our overall amount of that. And again, what you can see, this is a little bit hard to see because of the colors, but Alaska and Hawaii are exempt. Let's see if I can find a pointer here. Alaska and Hawaii are exempt, thank you, Sarah, here and here. Interestingly enough, Vermont is also exempt, as is Washington, D.C. Different states, again, had different having the highest percentages that they needed to reduce. Other states that primarily rely on a mix of electricity sources, but coal-burning plants had 31 to 40% reductions. Further west, where you're looking at more hydroelectricity and different kinds of reductions, fewer reductions required in those areas. Keep this map in mind as who is suing about the Clean Power Plan, and you can see some similarities. States under this was supposed to pick an option by September 6th, coming up shortly, and submit an initial plan with federal authority as a backstop. One type of plan they could pick was an emissions standard plan, really looking at different source-specific requirements, making sure that every affected power plant within the state met targets, emission performance rates, or state-specific based rates. It was really looking at kind of best technology to be able to reduce those rates. The other way of doing it was to say, hey, let's pick a set of measures within the state to meet these targets. Could you do renewable energy portfolio standards? Can you improve residential energy efficiency? Are there things that you can do as a state in combination with the federal laws and have enough measures packaged together to meet those reduction standards? Phased over a number of years, the Clean Power Plan set out a number of dates. Again, interim standards with the first requirement supposed to have been due September 6th, and then dates following thereafter. All of this was backstopped by federal authority, or it's deemed insufficient by EPA. We will come in with a federal implementation plan and basically tell you what to do. So that's kind of the backdrop on all of that. Again, I don't want to belabor that. The legal challenges against the Clean Power Plan were very, very swift and numerous. I alluded to the fact that the draft Clean Power Plan was released in 2014. And again, this was the lawsuit that came in right afterwards to block that draft rule. The court said, no, that's premature. You can't do this until it's filed as actually a final rule. August 2015, it's announced. They try and sue again, basically saying, hey, this is still too early. It has not been published in the Federal Register. You have to wait. It's finally published in the Federal Register, and very promptly a number of states in the industry sue and ask for a stay. In January of 2016, January of this year, the DC Circuit declined to stay the rule and basically said, no, the rule's going to stay in place. In between, basically, September, October, November, December, more than 50 different lawsuits were filed, by and large challenging the Clean Power Plan. And the general gist of most of those arguments, and I'll come back to what's before the court right now, the Environmental Protection Agency overstepped its bounds. A lot of the rules really relate to specific provisions under the Clean Air Act, 111D and 111B, looking at different air pollution standards for different kinds of sources. But the core of a lot of the arguments is it's a federalist question for the United States. Is it in the power of the federal government to really regulate and tell states what to do with their energy mixes at the state? On the other side, the Environmental Protection Agencies and supporters of the Clean approach, where we're not dictating what the states must do. They can choose their own path forward, but for the health and welfare of the people of the United States, given the health impacts of climate change, given the economic impacts of climate change, this is a path forward. So again, the arguments are more detailed, but those 50 plus different sets of suits all basically are pushing back and forth at that core question. Is it in the federal government's authority to really challenge these plans? In a surprise move, and reading a lot of the legal commentary about this, it would be unusual apparently for the DC Circuit to actually issue a stay, basically saying these rules do not go into effect until they are heard on the merits, the actual arguments in play. DC Circuit declined to stay the rule that was appealed to the US Supreme Court. And in February of this year, the Supreme Court granted the stay in a 5-4 decision to freeze it while the litigation was happening at the DC Circuit litigation. A handful of days after that stay was issued, Justice Scalia died. So a 5-4 decision would have become a 4-4 decision, which would have been a no decision. However, he has upended what anybody thinks might happen with an eventual challenge of the Clean Power Plan to the U.S. Supreme Court. I mentioned earlier, the D.C. Circuit Court is scheduled to hear oral arguments en banc, meaning it's the entire court. They had originally actually supposed to have been scheduled to hear it in June of this year, June 2nd, and they postponed it on their own motion. It had been 3 judges who were supposed to hear it, and they basically decided, no, we're going to add everybody who is on the DC Circuit Court. However, there are 3 judges, including Merrick Garland, who is the nominee for the U.S. Supreme Court, who have recused themselves or taken themselves out of hearing the case. So again, coming up very soon is the next major piece of this litigation. The folks that are, the states that are suing, there's 27 states here that you can see who are actually outright suing. West Virginia is in the lead. But again, if you think back to the map that showed the states with the highest percentages of thou shalt reduce your emissions, it matches a lot of those states, particularly in this area, although not universally true. Reliant on coal as an industry, or have been reliant on coal as an industry. West Virginia is a good example. One state, Nevada, is opposing but not suing. 3 states are not suing. They're sitting back: Idaho, Tennessee, Pennsylvania. You have 1 state that's exempt, which is Alaska. You also have states that are supporting, and supporting in this instance meaning they're coming out in support of the U.S. Environmental Protection. I have filed briefs saying, yes, we really support this. West Coast, New Mexico, some in the Midwest, and New England. Exempt and supporting, Vermont is in that category, Hawaii is in that category, and I am missing the 3rd state that's in that category. It may be Washington, D.C. That may be a bit hard to see. I'll touch back on Pennsylvania in a moment, but this is an interesting place that has been a primarily coal burning place, has used coal as its primary source of production. A change in leadership over the last handful of years has actually really changed the political stance. The other thing I would say is there's 1 state, and I cannot remember which one, where the state attorney general is seeking to overturn the Clean Power Plan, but the governor is in opposition, so sometimes you have a split like that within the states. Moving forward, when they issued the stay, very importantly, is not on the merits of the Clean Power Plan. This is the entirety of the decision from the U.S. Supreme Court in February. It simply says that, and this is the official name of the rule, the carbon pollution emission guidelines for existing stationary sources, also known as the Clean Power Plan, is stayed pending disposition of this petition for review. If a writ of certiorari is sought and the court denies the petition, this order shall terminate automatically. Meaning, if the case is heard at the District of Columbia Circuit Court, and they ask for review by the Supreme Court, and that is granted, then this stay of the rules terminates. So it's a very brief decision. It just deals more with the procedural posture of the case versus the actual content of the case. But what it also means is that states don't necessarily have to comply with the Clean Power Plan or its deadlines while this set of cases is pending in front of the different courts. A little bit of context for this. This was actually from February, just after the stay. This is a column from the Washington Post. They basically say, hey, stay was issued just yesterday until the rules are resolved in court. But I think this quote is really interesting to be able to say is, a lot of folks have said the Clean Power Plan is unprecedented, and other commentators is saying the Clean Power Plan is not only unprecedented, but it's the most ambitious climate-related initiative undertaken by the Environmental Protection Agency. It also relies on unprecedented assertions of legal authority. And to be clear, again, according to this commentator, I mean just that. There is no precedent. This is not the same thing as saying that a specific argument or action is unlawful or that courts have not had the cause to answer before. So I think this is a really critical point for this, is that the Clean Power Plan was broad in its scope and its reach. It is built upon previous legal precedent under the Michigan case and the other case decided in 2014, but it is raising a lot of really novel questions for the court to really consider. I think Barb Kinney just wrote in the notes that Colorado was the state with the governor-attorney general conflict related to it. And again, Colorado's primary source of energy is probably not necessarily coal. I haven't dug completely into Colorado's source of power. But it is just even the nature of having different parts of government in some states pitted against one another, I think highlights and illustrates how difficult and challenging an issue this is for folks. Again, oral arguments are scheduled on September 27th, 2016 for the DC Circuit Court of Appeals. And I would give a side note to this. I actually had an opportunity to take a whole group of students down last year to hear a Federal Energy Regulatory Commission case argued in front of the U.S. Supreme Court. And I thought, all right, I might have some challenge getting in with my students, but we got there plenty in advance. That case had 400 people from the entire power sector across the United States standing in front of the court waiting for that decision, or waiting for that oral argument. I had no idea that an energy case would be the blockbuster case that it was. I would anticipate that this case coming up, that if you wanted to actually, wanted to see it, I don't know when you'd need to get in line or what the capacity is, but I would expect that this also would be a tremendously well-populated case given the number of, simply the number of attorneys, the number of parties who are engaged with it. Again, the argument against this is EPA really doesn't have the authority to force states to transform their energy systems away from coal-fired or fossil-fired plants. In the in the briefs already submitted, they quite clearly say this plan commandeers and coerces states and their officials into carrying out federal energy policy. And they go very specifically to an exclusion under the Clean Air Act, which prohibits the Clean Power Plan. In contrast, the EPA argues that we properly exercised our authority to include a shift in generation, again, away from fossil fuels to other sources. We have the discretion. There's something called the Chevron doctrine that basically says if an agency makes a reasonable decision and if they have discretion and their interpretation is reasonable and entitled to deference, then the regulation is not necessarily barred, that they are given deference for their opinion. They say, you know, this doesn't pose any constitutional issues, that we didn't have any justified and achievable and realistic degree of emission limitation using the best system available. We looked at the statutory factors, we calculated state-specific goals, so we should be good. But again, as I mentioned earlier, the real core of these legal arguments come down to a push and pull between who has the right and ability to regulate. Is it the states? Is it the federal government? Is it shared? And if it's shared, is this an allowable way to do this? If you want links to... So where are we right now? We're in a place where a number of states are actively fighting compliance. They are actively suing about this, and they are not going to comply anytime soon until they are made to, if the decision actually goes forward. You have a number of other states, about 19, who are not officially planning, but they're kind of on the actual implementation of the Clean Power Plan, taking a wait-and-see approach. You also have a number of states that are moving forward despite this stay, saying, okay, we might take a breather because we actually have a little bit more time. We may not be under a mandate to actually meet a September 6th deadline for submitting our plan for what we're going to do, but we're going to move forward anyway. And I think in the last webinar you heard from Washington and Oregon, who are both states in that situation where they're moving forward and trying to figure out how to actually implement the Clean Power Plan. I know Washington, for example, has been holding a number of active hearings, reaching out to stakeholders, and really trying to figure out how to move forward. For the states that are actively fighting it, some of them have enacted bills saying we're going to prohibit submission, this is Kansas, submission of a state plan if the plan would adversely impact the state's legal position in pending. We're going to develop a state plan to comply with this unless the stay is lifted. If a state plan is developed, the State Department of Environmental Protection would be charged with drafting a plan and submitting it to the legislature for approval before submitting it to the EPA. So it's choose your own adventure. If there's a stay, we don't do anything. If the stay is lifted, you have to come back to the legislature for our review and approval before you go forward. Wyoming, you can't use any state funds to develop a state plan while the Supreme Court stay remains effective. Again, in contrast, you have other states. Pennsylvania, again, coming back to Pennsylvania, is continuing to work on the Clean Power Plan. The change from a Republican to a Democratic governor has meant, I think in part, that what has been a traditionally coal-based economy is really trying to figure out, well, how do we address these issues, particularly as you have the Marcellus shale development and the advent of a lot of relatively inexpensive natural gas coming into the system. Different state a little bit further, and just actually last week, just 6 days ago, California actually was the first state to file a compliance draft, and just exactly 1 year after President Obama announced, hey, we were really a leader in clean energy, we want to keep doing this. They had passed a bill called Assembly Bill AB 32 a number of years ago, setting their own greenhouse gas emission reductions. That had been widely accepted and by a bipartisan group of folks a number of years ago. I think reductions under the Clean Power Plan, and given the volatility at the national level, I think is a little bit more dicey in California than it has been politically, and a little bit less straightforward for moving forward than the Assembly Bill 32 had been. The bill had been subject to quite a bit of litigation all by itself, and really watched as California was working through the greenhouse gas emissions. But California, again, is the first in the country to actually submit their information to the United States Environmental Protection Agency for review. There are a lot of questions and uncertainties about this. I don't need to tell anybody that we've got an election coming up, which is wreaking havoc, I think, with people's feelings of certainty and about where anybody would go. I mentioned earlier that Justice Scalia passed away soon after the stay was issued. We are missing a Supreme Court justice right now. And if you look at a lot of the decisions that have come back from the U.S. Supreme Court on energy or environment-related issues, they've come back as 4-4 decisions, or they've come back as the Supreme Court basically saying, we're not sure, go back to the lower court, you go figure it out. It's very, very unusual to see as many decisions as the U.S. Supreme Court seems to be making right now that are effectively punting making a decision. I mentioned earlier that Merrick Garland has been nominated to be the replacement U.S. Supreme Court Justice. If the entire panel of the D.C. Circuit Court were to be together, he normally would be on that case. Again, he's recused himself for taking, because I think he's been nominated for the High Court and he knows this is a case that will come up in front of it. There's another side of this, which is the entire coal industry is under a tremendous amount of flux and change. 2016 has seen record amounts of declarations of bankruptcy for the coal mining companies, Peabody, Arch Coal, you name it. really a huge number of the coal companies have declared bankruptcy as they are struggling with lower prices and lower demands. At the same time, I mentioned places like Pennsylvania, but elsewhere in the country have meant that the price of natural gas the amount of natural gas is quite a bit more abundant, but the price is quite low. That also is really changing both the domestic energy market, but also the international energy market. This year in 2016, you saw the first exports of U.S. natural gas, both to Norway and then to Portugal, or Portugal and Norway. I can't remember which one was first. But that's the first time the U.S. has ever exported natural gas to other places in the world. A different legal battlefront, pipeline development is kind of in states like Pennsylvania, where the price of natural gas in some parts of the state is quite a bit lower than other places where there's a higher population base. So a lot of these key questions, both politically as well as just market demand and pressures, really add a lot of uncertainty to the Clean Power Plan. A number of commentators have basically noted that the Clean Power Plan in some ways was canary in the coal mine, but was an entity that, or a set of laws that worked as a driver and maybe was aspirational, but the market pressures are maybe actually driving an effect in the reduction in greenhouse gas emissions much faster than the Clean Power Plan ever could have. Again, so it's a complex and volatile set of dynamics here at play all at the same time. At the same time, I mentioned earlier that Environmental Protection Agency, one of the first things they did in advance of issuing the Clean Power Plan was to issue an endangerment finding. And about 2 weeks ago, the Environmental Protection Agency actually issued another endangerment finding saying that the greenhouse gas emissions from aircraft endanger human health and the environment. So even as the hallmark climate change reduction plan for President Obama is in a great deal of uncertainty and awaiting the legal arguments in about a month's time, a little more than a month's time, the administration is continuing to proceed with other major greenhouse gas emission plans. And so regulation would come out before the end of the year if it would be in draft. But one of the things that was discussed but not eventually written as much into the Paris Agreement was related to aviation, and yet if you look at the amount of greenhouse gas emissions, it's a pretty significant amount. So, I mean, again, I find this interesting. While on one hand, one piece of the portfolio for greenhouse gas emissions is seriously being thought about, another whole program is in the mix and coming on board. And so Janet McCabe, you can see from the quote further down on the page here, is regularly testifying in front of Congress right now. See if I can get the arrow to move down at the bottom of the quote. But she is definitely the one who is spearheading and leading the charge with a lot of the efforts to deal with and address the greenhouse gas emissions. So stay tuned. Another marquee thing, and I think one of the things, the reason this has caught my attention is there's a lot of discussion in the world of biofuels about biofuels as a way to deal with greenhouse gas emissions from aviation. Could you create biojet? It's maybe not quite as much on the radar screen of your average American, but the amount of emissions from aviation is under a great deal of scrutiny, both here in the US but also in Europe. So something to watch. I put a couple of references. This is a link to the EPA site for the Clean Power Plan and the existing power plants. E&E News, I referenced a couple different things, has an entire set of the documents in the Clean Power Plan. There are other sites plan and in opposition. If you want to read through layers and layers and layers of legal documents, again, this is a gangbuster of a case. A number of folks have said we've never seen a case this big. There are literally the number of attorneys in the different parties supporting or in opposition of these plans is pages and pages and pages of names. So there's lots and lots of material out there. I have no idea if the DC Circuit Court will live stream or make available the transcripts of the hearing, but it will be interesting to see what they pick up and really focus on as they hear this case in about a month's time. So I'm happy, this is a little bit quick, but I'm happy to answer any questions people might have and or even get into a discussion with folks.
Thank you so much, Laura. Yeah, I'm really pleased to see the list of participants we have. It looks like we have some people who are, I recognize some names who are actively working with their state air regulators on this type of thing. Several others are listed, are members of some of the statewide wood energy teams that have been established through the Forest Service. So please let your questions fly. I would like to hear from most of you if you have questions about this. Laura, I kind of just want to get a sense of, what might happen now. I know it's tough to hypothesize about what the possibilities are in such an environment of uncertainty, but so, in September we start to hear what have similar issues done in the courts. So, how long are these battles usually drawn out when it comes to this type of regulatory question? If it's, do you expect appeal after appeal? If it's drawn out that long, are there going to be, is the stay sort of potentially infinite until something much more decisive happens?
Yeah, that's a great question. So, I mean, more typically what you would do is have a hearing by a 3-judge panel. They'd make a decision and people would decide, oh, I want to appeal that either back to the court as a full, an en banc panel where, again, instead of 3 justices, you would have 10 or 12 hear the case. The DC Circuit skipped that. They actually short-circuited the time it would take to hear it and then hear it again by, on their own motion in June of this and late May this year, taking that oral argument from June and forestalling it until September this year. So that shortens the time frame. Folks are expecting that they will make a decision by late 2016, early 2017. It is expected that whatever decision they make, it is expected that that will be requested for review by the U.S. Supreme Court in early 2017. And taken up probably in 2017 into 2018. Again, because the court is short 1 member, the Supreme Court is short 1 member, that's caused some funny things to happen. And no one's quite sure how to read the court right now, but because this is such a major case with so many parties and of such national importance, it is assumed that they will take it up. Going back to the DC Circuit Court, they review a lot of decisions coming from, or a lot of regulations coming from federal agencies. And by and large, they're seen as having deference to an agency decision. If the agency has thought through the science and the law and issues a well-reasoned set of rules, they are more typically, again, as the commentator from the Washington Post noted, we're in a little bit of uncharted legal territory. So it's not entirely clear what decision will come out of it. Again, but it is clear probably that whatever the decision it is, it will be appealed. Just by reference, the U.S. Supreme Court gets about 10,000 requests to review cases or petitions for certiorari every year. They see or they hear 90 cases. And so it really has to be a pretty major case for the court to take up, but this is so important that they can't not take it up, is I think what people are saying about it. And they've already indicated an interest by issuing a stay, which is also unheard of, has maybe very, very rarely happened. So the hope is that by early 2018, you'd actually have a decision on the merits of the case, and that would deal with the stay one way or another. Does that help answer your question, Sarah?
Yeah. You mentioned that it's in a lot of these scenarios, they usually defer to the scientific expertise of the regulating agency. Do you think that is strengthened by the fact that there is this 2007 precedent at the Supreme Court level that you mentioned that allows autonomy within EPA to regulate carbon emissions?
that decision, and that dealt more with and set the stage actually for EPA being able to regulate emissions from transportation. So they've set a lot of new rules for cars and trucks, for example, particularly lightweight trucks, where EPA was saying, we don't have the authority, we can't do this. And so, and one of the questions that just came in is, what about this case is unprecedented? I also see the other question that's up there, but what areas of law have precedent set for them? So it's really that 2007 case, Michigan versus the Environmental Protection Agency, where Michigan was saying you actually have to regulate greenhouse gas emissions as a pollutant, that sets the stage to some extent for this decision, where EPA was the entity saying, no, 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 we can't regulate, we're not allowed to, and the court saying, you must. And so that has set off a whole cascade of cases where the EPA is trying different regulations for transportation, for the electricity sector. This is where you're really seeing it on the electricity side, or the power generation side, to be able to handle these types of cases. But part of what's unprecedented is there isn't that much case history. You really have from 2007 till now, which is about 9 years. But in the legal world, that's just tests of the different provisions to have gone all the way up through the system. And again, I think partly the grand idea that states have by and large had some autonomy in developing their own generation systems has shifted a little bit in the late 90s as you got into ISOs and RTOs, let me translate, independent system operators and the regional transmission organizations, to handle more integrated grid systems. But at the end of the day, the states really have their own ability to regulate within state boundaries. It's when you get into intrastate, interstate boundaries across state boundary lines that FERC comes in, Federal Energy Regulatory Commission. Again, so you see both the Environmental Protection Agency and FERC really struggling with how to deal with the federalism questions. What can they require states to do? Cross state boundary lines versus what are the states allowed to do within their own states. I'm not sure I answered that all that clearly, but those are some of the unprecedented questions I think that are coming up through this. And so the narrower arguments really are there specific provisions in the Clean Power Plan allowable or not? The larger questions are the federalism questions.
So I'm going to get to in just a second, but I just want to follow up on what you're talking about now. So we're talking a lot about precedent. If the Clean Power Plan is successfully struck down in legal proceedings, are there other elements of the Clean Air Act or in some of these sort of accessory precedents that maybe aren't robust precedents for this, but still certainly feed into the decisions being made, that challenges the EPA's authority to regulate in certain systems?
Short answer to that is yes. I mean, certainly this decision on the Clean Power Plan does not throw out the entire Clean Air Act. It's just on a very narrow set of provisions that they use to develop the Clean Power Plan. And again, that's partly what I'm so fascinated watching the aviation, the endangerment finding on the aviation. That paves the way for new from this. And again, I'm fascinated by the timing where, Obama seemed to be a lame duck. But this is a major initiative that he's taking on as if he's not about to be finished with his presidency. So I don't know what the timing, as I said earlier, will be on that. But they're moving forward. They're moving forward not only with aviation, but also in regulating the emissions from cars, but also light trucks. They're also looking at heavier duty trucks. So think about your delivery trucks on the road or your semis. Those have typically been exempt from regulation, but they're trying to figure out how to regulate those under the Clean Air Act because of the carbon dioxide emissions and emissions questions. So there's multiple fronts and there's multiple avenues. As I said earlier, Janet McCabe from the Environmental Protection Agency seems to be a very regular attendee in front of Congress these days as they pull her up front to yell at her about the next new initiative that she and her folks on the air quality side are working on. Congress probably feels a little bit like this is whack-a-mole, where we keep telling you, slow down on all these regulations. Can't you tell there's an election coming up? President Obama and the Environmental Protection Agency is moving forward. So Certainly, again, the state level are really trying to deal with it. I mentioned California. There's others in the Northeast with the RGGI, the Regional Greenhouse Gas Initiative, where folks are working on a cap and trade program through different states and the different regions. And there may be actually more opportunity at a state or a regional basis than you get in the swirl of the national politics and the dynamic, because it is so fraught right now.
Thanks. I want to circle back to Tim's question. He asked, has EPA moved on or tipped its hand regarding treatment of biomass solid fuel for stationary sources? As of early July, it appeared to still be waffling. Do you have any insight on that, Lara?
Short answer is I don't. EPA is waffling on a lot of the biofuel and biomass standards right now. They're struggling for actually in the standards for 2016, 2017, 2018. So even as they're moving forward on other initiatives, for some initiatives that are already underway, they are still waffling. I don't know, but I can actually find out and see if they've moved any, Tim, and follow back up with you if that would be of help.
That'd be great. Looks like Tim is typing in to respond to your question. Okay, we've got another question from Shiva Kar. He asked about the transportation sector is responsible for about 26% of greenhouse gas emissions compared to 30% from electricity generation. So you mentioned about the EPA's plan for the aviation sector. He asks if there are any other EPA initiatives to check other sources of transportation-related emissions, since it, on the overall landscape of emissions, it's a much more significant percentage.
Yeah, and that's what I was alluding to is yes. They certainly, with cars, you've seen pretty serious emission standard changes, but also with light-duty trucks and the heavy-duty trucks. That's not quite the exact legal term, but the big, the semis of the world, all of those are seeing regulatory requirements come down, and that's got the transportation industry more than a little bit freaked out right now as well. But it's all state about the transportation side of it. Folks are not exactly sure what the economic ramifications of trying to change out and increase the efficiency of our truck fleet might be. By and large, that segment of the population of transportation vehicles has been exempt from the Clean Air Act. And again, that 2007 decision, the Michigan versus EPA decision, was a groundbreaking change that was directed specifically at the transportation industry, and is paving the way for new regulations in that area to deal with the emissions coming from the transportation sector for energy. So another completely different area, but it is tied to biofuels. It's tied to biomass use for fuel, and it is tied a little bit again to the renewable fuel standards as what's possible technologically, but also what's being required by law. So it's a whole other sector that's in a great deal of change right now.
Do you think the model that's presented under the Clean Power Plan, by allowing states some freedom to self-determine the ways they want to attack this problem, is particularly amenable to those types of future problems that might pop up? Since there is this sort of initial review process with EPA before you're committed to the plan that you've presented, based on what you know about similar regulatory actions that have happened in the past that may not have had such a model?
That's $1 million question. When our system of government was set up, it was set up with the idea that the states were little petri dishes where we could try stuff out. And different states could really push the envelope. California is a classic example where a lot of standards that are tried out in California eventually become the national standard. California as a state government is something like, it's in the top, I think it may be in the top 10 largest economic units in the world by itself as a single state. And so what California says often goes as the national standard. I don't think that's a bad model to have where the states get to try out stuff. I alluded to the AB 30. California's commitment to greenhouse gas emissions at the state level. But again, because the California market is so big, when you saw the lawsuits, both a state set of lawsuits and a federal set of lawsuits about that bill and what was required for greenhouse gas emissions, reductions through fuel standards, renewable fuel standards in that state, it looked like a national case. I think the really interesting thing about the energy sector in particular right now, be it for transportation or for the electricity side, is our country as a whole, and even North America as a whole, is in a state of tremendous, tremendous flux. If you look at the energy utilities of the 80s, say, or 70s or 80s, this was a boring area. It wasn't changing that much. You have deregulation in the 90s. You have the ISOs and RTOs, the independent system organizations, and the regional transmission organizations come on play. And they're the largest electricity organizations most folks have never heard of. If you look at PJM, the Pennsylvania, Jersey, Maryland Interconnect, it's an enormous area. And it's really struggling to balance within that area the energy generation portfolio lines. And so to some extent what you have is the states trying to control and manage their own autonomy. At the same time, you're dealing with a much more interconnected system than you've ever had before, and a global issue like greenhouse gas emissions that you're struggling to deal with. So I don't have an easy answer. I do like states as again, that petri dish or a place to try things out. They can be a little easier to move given our national dialogue is so locked up. But these are very, very, very hard issues for folks to figure out. They're also very hard issues, again, listening to the Supreme Court in person last year, they're very hard for the court to figure out. And I think it's actually incumbent on the energy world to figure out how to help the lawyers of the world figure out how to regulate it. So you had the Supreme Court justices honestly discussing energy flowing through the system as if it was a car or a hamburger, a fungible good you could put your hands on in some way, when electricity flowing through the system is really kind of something different. And so you see the justices struggling with how to describe the technical attributes of a system that's pretty complex, and they're trying to regulate it. Again, in this sea of lawyers and briefs and friend of the court arguments, I mean, the volume of material is enormous. And again, maybe also unprecedented from that standpoint. So I think it's a real struggle. I think it's a dynamic struggle that you'll continue to play out well beyond November of this year, but years to come as the states and the regions and the country is trying to figure out how to manage a system that's changing very, very quickly right now.
Yeah, and if that level of complexity is being, is playing out in the courts and with these, policy experts, the complexity as it comes down to state level legislators is even greater. So I want to ask you some questions about, can you give some context for how legislation usually kicks into gear around a major regulatory policy like this one? So you already mentioned different parts of government being pitted against one another. The proposal in West Virginia to have regulators submit a plan to the legislator for review before it's submitted to EPA. I think Pennsylvania has considered something similar. Then you have cases like Senator Collins trying to push across the board carbon neutrality declarations for biomass as a part of the qualification scheme for the CPP. So is it normal for these kinds of legislative actions to pop up on the margins of a major regulatory policy administered by a federal agency that is separate from Congress? So maybe that's a silly question with an obvious answer, but bear with me, I'm a forester and not a lawyer. I'm curious to hear your thoughts on that.
Yeah, no, again, it's another great question. I think folks who really don't have experience with this kind of huge, encompassing, we're going to change all the rules and we need you as states to comply type of regulation. The most parallel example that I can think of is actually in the water realm. Under the Clean Water Act, there's been a lot of litigation, a lot of questions for years as to what is the regulatory authority and reach that the Environmental Protection Agency has under the Clean Water Act. What is their jurisdiction related to, quote, navigable waters? And the splits all over the place, and EPA basically said, look, this is a mess, we're going to write some rules, we'll be really clear about where we have jurisdiction and where we don't. And folks came unglued when those rules were written. They're, on one hand saying EPA overstepped its boundaries. On the other hand, other folks were saying, oh, this is great. We finally have some clarity as to where the extent of federal jurisdiction lies. That also is tied up in the court. Again, you can see why EPA is regularly hauled in front of Congress for hearings, not only on the air quality, but the water quality side. You have a lot of pushback against the agency as a whole right now because those types of issues are coming up and playing out, where on supporters of the EPA will say, look, we don't have the water quality and the air quality problems that China has because we have an entity like the Environmental Protection Agency. You also have a lot of businesses in a lot of states saying, but you're overreaching. This is states' rights, states' boundaries. You're in our territory. Leave us alone. So it's not just air, it's not greenhouse gas emissions, but it's water. It's all the way through what EPA is working on. They're getting just a huge amount of pressure on it right now. And it's not clear how this is playing out, but what you do see is the states kind of trying to defend their own territories, if you will. So not a dumb question at all, but with all of these things, we're in.
Thank you. We probably have time for one more question if any of our participants would like to pose one. In the meantime, I want to say thank you so much to Lara for joining us today. This is such a complex issue. There's so many moving parts, and we who work in the realm of biofuels, only some of us have robust policy background. Others are working on the production or procurement side of things, and it's great to have somebody really lay out the whole timeline, the overview of the context for this kind of thing. It really benefits us all in the work that we do with the stakeholders around this and other similar policies. So I want to thank you again, Lara, for joining us and helping to clarify the whole landscape of what this means for us and what the future might look like. Coming in, although if somebody really wants to sneak one in, that's fine. For now,
Can I make one plea to everybody on the phone or everyone on the line? So my plea would be this. I've worked a lot with different legislators, both at the state and the federal level, but my plea is this. When you guys are working on complex issues, if you can figure out how to help people understand what the relevance and importance is and think how to really distill what you're working into shorter, more workable pieces for those legislatures, there's really a keen interest in understanding. But there's an equal barrier going back from the policymakers and the lawyers of not wanting to look dumb, not understanding the world that you live in, but there's a real appetite to actually understand the science and why it matters. So if you can find those who are willing in the state legislatures to sit down and talk with you, even in Congress, it doesn't matter either side of the aisle, people will listen if you can figure out how to communicate your work back. But it's absolutely critical. Again, listening to the Supreme Court argue about what electrons, if they're like a car or a hamburger, struck me as such a critical need for helping people in those decision-making capacities really understand the systems you guys know really, really well. So that's my flip side plea. If you want the regulations and the laws and the court, they also need to understand
Lara.
the science.
I was just about to ask you if there's any, final thoughts you want to leave us with, and those certainly, that's a great final thought. Is there anything else you wanted to mention before we all go?
No, but stay tuned, and I will figure out if I can actually live stream or watch the DC arguments, and maybe, Sarah, what we can do is send out an update after that point. But it will be in the news. It will be all over the place. This is a big story.
Absolutely.
So
thank you so much.
I appreciate everybody's time and interest in the topic.
And if you do issue any of those updates or maybe some written material, I will post those to the same website where you've been looking for updates on this webinar series, so you should be able to find it there. You can also contact me or Lara or anyone else within the New Bio Project to follow up. Thank you all for joining us today. I hope you have a great day.